This is our Knowledge is Power series. I will be going through some of our agenda items. First off, though, we will introduce ourselves. I am Cheryl Rotyliano. I work in the Career Services Office at IC, with some of my main responsibilities being to see students and alumni as well, helping with career coaching topics and self-advocacy being one of those things, right, that I think needs a little bit more attention. So happy to see you all and hope to connect after this as well.
Hi, everybody. I'm Emily Rockett. I'm an assistant counsel in the Office of the General Counsel, where I focus largely on employment law. Prior to working at IC, I did employment law and labor relations for school districts in the Southern Tier at GST BOCES. And before that, I was in private practice at Miller Mayer, doing a fair amount of labor and employment counseling for local employers. And I'm really excited to see you guys. This is one of the, especially this semester, one of the few times I get to interact with students, and I'm really happy to share some general information about your rights with you.
Cool. So for our agenda, we're going to go over terminology associated with job offers. That tends to be a big part of the equation, both with knowing what you're being offered in a position, as well as knowing how to negotiate based on some of that terminology. We'll talk about some wage discrimination practices, some data to share, some information about benefits and your negotiations surrounding those. And then we're also going to give some resources of governing bodies with which to report discrimination and do some investigation stuff if you are to experience it.
I also just want to say at the outset, a lot of this is how to professionally negotiate and how to advocate for yourself. All of these things are really hard, and they get better with practice, and they are especially terrifying if you've never done them before. So just, we'll give you some pointers of things to watch out for, but this is one of those things where you just have to be patient with yourself and practice, practice, practice. So general overview of things to know. There are laws and regulations at different levels, state, federal, sometimes local. At the state level, they can vary quite a lot. So it's really important when you go to interview for a job that you know in which state you would be working, and you can get a sense of which protections would apply to you. For instance, California is constantly enacting new worker protection and is very, very protective of the employee side of the employer-employee equation. New York is just behind California. Other states, not so much. So definitely know where you're applying when you start thinking about what issues you might have and how to negotiate. There are exceptions to almost every rule. We do not have time in this presentation, or probably if we did a month-long class on this, to cover all the exceptions that exist. So everything we say is a generality. Take it with a grain of salt. If you need to know, start doing research with the pages that we give you at the end with the enforcement agencies can often provide a lot of helpful fact sheets that you can look at. Or if you are in a situation where you feel like you need advice, talk to a lawyer who's licensed in the jurisdiction where you're looking to work. And on that note, the scope of the presentation is to give you an overview of the issues that exist and empower you to ask the right questions in a situation where you may need to do so. We can't give individually tailored advice in this format because we don't have attorney-client privilege. So just know that, take the general information that we give you and use it to, seek the more specific information that you may need later on in your process. Next slide. All right, so overview of what protections exist. Title VII of the Civil Rights Act of 1964 is the really big one. And under Title VII, it is unlawful for an employer to take what's called adverse employment actions based on protected characteristics. And an adverse employment action can include a wide number of things. It can include failing or refusing to hire you, discriminating with respect to compensation or terms of employment, or it could mean limiting, segregating, or classifying applicants in any way that would adversely affect their status. The third one, the really easy way to remember it is, I'm sure you guys have all heard of mommy tracking. Is treating somebody differently based on their status as a woman or the fact that they have or are planning to have children, based on the following criteria. And this is at the federal level. States can be more specific. This is the baseline that everybody has to follow: age, race, color, religion, sex, national origin, sexual orientation, gender identity, transgender status. Pregnancy is protected as well. The Supreme Court held in June of 2020 that firing individuals because of sexual orientation or transgender status violates Title VII's prohibition on discrimination because of sex. So these bottom three are sort of an offshoot from that middle one, which is important to remember because these terms can be defined differently based on case law or based on subsequent legislation. So for instance, in New York State last year, the legislature changed the human rights law to define race to include hair texture and protective hairstyles, such as braids, locks, and twists. So previous to that, it would not have been per se illegal for an employer to say it is unprofessional to wear your hair in braids and to discipline somebody for wearing their hair in braids, despite the fact that that is a very common way for Black individuals to wear their hair. Now you can't do that. So the law in this area is always changing, and it's really important to stay abreast of it. The thing that you may notice you don't see on here is criminal history, which is also very, very jurisdiction specific. Federal law doesn't prohibit employers from asking about your criminal history, which means your arrest or your conviction records. By contrast, there are a number of state and local laws, New York City springs to mind, that forbid employers from checking on your criminal history in determining whether to offer you employment. So look at the jurisdiction for which you're applying, and you may want to try the term ban the box. New York State in particular bans inquiries about prior arrest records that are not currently pending or have been resolved in favor of the individual, which means resulted in youthful offender adjudication or resulted in a sealed conviction or resulted in dismissal. A pending arrest or a criminal accusation is not protected. There are some exceptions to this where they can ask about the things that were listed, like resolving in favor or sealed convictions, such as if you're applying to be a police or a peace officer, or if there's a direct relationship or unreasonable risk with the crime and the job for which you are applying. For instance, if you're a bus driver, they get to ask about your DWIs. So what does this mean? Moving on to the next slide. There are a couple different types of discrimination that are prohibited under Title VII and case law that has come about interpreting Title VII, which includes disparate treatment and disparate impact. Disparate treatment is the more obvious form of discrimination, right? It's where somebody is intentionally making decisions such as refusing to hire somebody based on protected characteristics. And the way that you can kind of, I guess, notice disparate treatment discrimination is if, for instance, you're communicating in writing with a potential employer and they're really excited about your resume, they're super psyched to have you in for an interview, and you come into the interview and you notice much less enthusiasm, right? That's kind of a weird red flag that something about your appearance surprised them and that may be affecting their judgment. And then once you're in the position, disparate treatment can be obvious based on things like if a senior partner, I'll go with law firms, is only inviting male associates to after work socialization type things, right? That's a mentorship, that can be a mentorship relationship, that can be a provision of additional employment opportunities. And if only people of one sex or people of one race are getting that opportunity, that starts to look like disparate treatment. Disparate impact is a lot more insidious. We think about disparate impact when we think about things like systemic racism. That includes policies or processes that will have an adverse impact on individuals with a protected characteristic. It's a lot more difficult to pin. There was a Supreme Court case in 1971 called Griggs versus Duke Power, where Duke Power was administering aptitude tests for employees to reach a certain level of employment within the organization that came with higher pay. The aptitude tests had a tendency to promote white individuals over Black individuals, because in 1971, you were getting applicants who had been through a segregated school system or had otherwise been, the victim of segregation, especially in the South where this occurred. I believe it was North Carolina. And the Supreme Court found that these aptitude tests were illegal because they disparately impacted Black individuals and they were unrelated to the job duties. So they were just a hoop to jump through, right? And the employer could not draw a distinction or draw a connection between this is what the test is and these are the job duties and this is why this test is necessary to get people who are qualified. So if you're seeing things like seemingly unrelated hoops to jump through, that's a flag for disparate impact. Next slide, please. Other federal protections, just to give you kind of an overview. The Americans with Disabilities Act is a real big one that comes into play in a lot of different workplaces. And that's if you have a disability that substantially limits one or more major life activities. The big thing in ADA commentary right now is people with long haul COVID and how that's going to be interpreted in the workplace in the future. The ADA does not, this is really important, allow a pre-employment physical without an offer of employment. So once you get that offer of employment, if they want to, if the employer wants to pay for a medical exam to make sure that you're fit to do the job, that they can do. They have to pay for the exam, pay for your time to take the exam. But before you have that offer, they cannot require a physical. And the ADA also requires for individuals with disabilities that as long as they are able to perform the essential functions of their job with or without reasonable accommodation, you can't take adverse employment action against them. So in order to determine what a reasonable accommodation is, the employer is obligated to go through what's called an interactive process to determine what reasonable accommodations might be available. The Genetic Information Non-Discrimination Act prohibits use of genetic information in making employment decisions. They can't ask about your family medical history or get any kind of genetic test. The Immigration Reform and Control Act prohibits discrimination based on citizenship. So again, if there's something that comes up in the job interview phase, your national origin is not relevant to their decision as to whether to hire you. Yeah, any questions at this point? Sounding like no.
Okay. And so as we go forward, you'll have a more understanding, I think, of why we went over those things to start with, right? Those things as protected characteristics are places where you can be mindful in a negotiation process while you're looking for jobs, while you're working, right? Those are all kind of across the board protected characteristics. So to break it down in really probably oversimplified form, um, this is prohibiting employers from using certain criteria, as we just covered, from making decisions, right? It should not be a factor in making a decision. Whether, as we talk about different characteristics, whether that means that you're in a majority group. For example, in a company only wanting to hire a certain race, even if it's a majority group or not, right? It shouldn't be criteria used to make decisions. Okay, and so what we're going to do here, I'm going to launch a poll for everyone. We're trying to make this interactive for you. And so here is the poll. What makes you, as we transition a little bit to talking about negotiations, what makes you nervous in entering into job offers and also into negotiations? This, if you'll note, is a multi-checkbox, so feel free to check all of the ones that that you're feeling, at least at the moment. Seeing a good amount of people check more than one box, which makes sense. Okay, waiting for 2 more. Okay. All right. I am going to close the poll. I will share the results here. Okay. So we've got number 1 response, not knowing what to say, being unsure of what salary to ask for. We see some responses around confidence, and then a lot of ones after that, really, in terms of benefits, thinking discrimination might play a role, generally not knowing the process. And then one person, I'm not nervous. So I figured I'd have to put a spectrum in there. Okay, so thanks for doing that. We'll have another opportunity for a poll in a few minutes. So in titling this series, right, and thinking about negotiations specifically for this session, our intent in creating this was to empower you as students with knowledge so that you can advocate for yourself, right? So specifically with thinking about negotiations as well as job offers, terminology and sort of knowing what you're being offered, knowing what you're signing up for is going to be a big part, honestly, of what your employment relationship looks like. So we're going to go through some definitions that you're likely to see in job offers.
So the first thing to think about with a job offer, which you're probably going to be on the employee side of the equation, but especially these days with issues surrounding the gig economy, it's important to know the difference between an employee and an independent contractor. The actual analysis of this is really complicated, and it involves, I think, at least 11 factors. The federal government put out regulations fairly recently to try to, I guess, put a cap on the number of factors and make really clear which ones were more important than other ones. So I did include the ones that the federal government has proposed be given more weight on the independent contractor side. But the general idea is an employee is somebody who's under the control of the employer, and an independent contractor is somebody who works for themselves and is hired by an employer to do a particular task. The things you want to look for are, for an employee, the employer is choosing when, where, and how the services are performed. They're telling you when you can come, when you have to leave. They're telling you when your lunch break is. Odds are you're an employee. The employer provides your tools. You're not expected to provide your own computer or your own hammer if you're working construction. The employer sets the rate of pay because the employee doesn't have a lot of leverage in that situation. And of course, there's salary negotiations are an aspect too, but the idea is the employer is the one who's sort of starting that conversation. And especially if the employer is requiring prior permission for absences, if we're talking about paid time off, you're an employee. Independent contractors generally are running their own business. And the second one is really important, assuming the risk for profit or loss, right? If you're an employee, you generally get paid the same amount hourly or on a salaried basis, regardless of how well the employer does. If you're an independent contractor, your rate of pay can fluctuate depending on how much work you're able to get or what you're able to charge to various customers. Independent contractors are free to accept or refuse work even for competitors of the quote unquote employer. And independent contractors are able to hire help. For small independent contractors, this starts to get tricky, right? Because you've got a small independent contractor who maybe has one really consistent customer. Eventually, if they only do work for that customer and the customer has a lot of leverage over how they spend their time, that can start to look like an employee relationship. Next slide. The other important thing to consider when you're thinking about positions is whether you are exempt or non-exempt under the Fair Labor Standards Act. So let's start with non-exempt. It's pretty clear that the default for how you pay your employees is on an hourly basis. And over 40 hours a week, you have to get at least 1.5 times your normal rate of pay. There are some exceptions to this, but by and large, that's the rule. If you are exempt, then that means, first of all, you make more than the threshold amount that you need to be salary exempt. In New York State, that's like 46,000, 52,000 a year. I can't remember off the top of my head, but it's somewhere in the $40,000 or $50,000 range. Federally, it's much lower, which is why you can have assistant managers at McDonald's who are classified as exempt and make like $30,000 a year. And you also have to meet the duties test, which means you have some exercise of discretion or judgment, or there's something about your work where you are asked to get the amount of work you do per day may fluctuate based on your job duties, right? If you're in charge of people, you may have to stay a little bit later. You may have to do administrative type of things that require judgment. So the federal government has said you can get a salary. You don't get overtime if you're paid on a salaried basis. But if you work at all within a given week, you have to get the proportion of your salary that's attributable to that week, even if you work 15 minutes. This became a really major issue during COVID when people were thinking about partial furloughs, right? They wanted to say, okay, I'm going to make my salaried people work 80% of the time and pay them 80% of their salaries. And a lot of employers were surprised to find that you can't legally do that unless you convert that person to hourly employment or give them entire weeks off at a time. So yeah, and you also, it would be an important question to ask both whether you're salaried or hourly, and if you're hourly, how much overtime you're expected to work, because that factors into how much money you can expect and how much time you can expect to spend at the job. And some jobs, they'll work you a lot of overtime. Other jobs, they really want to dissuade you from working overtime. And in fact, working overtime without permission can get you disciplined. But if you work overtime without permission, they have to pay you for the overtime that you worked and then take the disciplinary action, which is a little known fact that sometimes employers like to not tell you. Next slide. Another crucially important factor when you're trying to figure out what your job is. Are you an at-will employee or are you subject to an employment contract? And this is another thing where different states have different rules, right? So New York allows employment at will. Other states, if you're an employee, you have certain protections and you can't just be fired for no reason. And even in states where you can be fired for no reason, it can't be an unlawful reason, right? Like it can't be a discriminatory reason, such as the ones that we listed earlier, which actually fundamentally makes it imperative for the employer to have some sort of justification for why they're terminating your employment so that they can protect against allegations of discriminatory behavior. So employment at will means either party can terminate the employment relationship at any time for any legal reason. You hear 2 weeks notice? 2 weeks notice, at least in New York State, is not a legal requirement unless it's in your contract. It is a courtesy that you give to your employer. And again, some states place limitations on employment at will and require notice provisions or things of that nature, and just make sure that you know what the rules are in your state if you ever, so that you are prepared if you want to leave your job. And then the other type of employment is if you're subject to an employment contract. And this can take a number of different forms. You can have a letter with your name on it that says, I, Emily Rockett, agree to be this position at this company from X date to Y date at a pay rate of Z. Or you can be in a position which is subject to a collective bargaining agreement, right? If you're in a union, then the terms and conditions of your employment are going to be governed by a collective bargaining agreement that your union representative negotiated on your behalf. And that's really important to remember too, because you can't, if you're unionized, negotiate unilaterally with your employer. You have to go through the union rep. And some things that wind up in employment contracts that you need to watch out for are non-disclosure agreements. So, I mean, basic stuff, make sure you read the contract before you sign it, right? That is generally applicable to every contract you ever sign in your life, but it's especially important for your employment contracts. If you violate a non-disclosure agreement, what's the penalty? I can almost guarantee you if there's a non-disclosure agreement, it says what's going to happen if you violate it, and you're probably not going to like it. Confidentiality provisions, same deal, like know who you can talk to and what you can talk about. And then non-compete provisions. Non-competes are really tricky because quite often they're unenforceable, but you are probably not going to know that going in because the law changes on them quite frequently. I think the most recent case I can remember regarding non-competes was I think Jimmy John's had a non-compete for their sandwich makers, saying that they couldn't go work for competitors after they stopped working at Jimmy John's, which basically meant they couldn't go work for Subway, right? And the court found that that was unreasonable because there's not specialized skills and knowledge, and the employer is not invested in training that employee on how to make sandwiches to a degree that would make it unreasonable for them to go work for a competitor. Doctors, quite often, they will find the non-competes enforceable because the employer will hire the doctor and they will subsidize their training, they'll pay for their insurance, they'll make sure they get professional development, and just invest quite a bit into the development of this doctor as a doctor early in their career. And so part of what the court looks at is reasonability restrictions. They'll uphold a non-compete covenant where, say, the doctor can't solicit patients within a 10-mile radius of the hospital where they started. Basically, that means that you can tell a doctor that, look, I'm going to dump a bunch of money into your education and you can't just leave and take all my patients. That's probably okay. You can't ever work again in your profession in the entire United States, probably not going to hold up. But again, if it's something that makes you nervous, something that makes it seem like you're tied to this employer forever, you might want to talk to an attorney before you sign it. Next slide.
I'm just going to launch a poll really quickly. So in going through those definitions, some of the different, circumstances that you can find yourself in with employment offers. No right or wrong answer with this poll that I'm going to launch, but of the options, right? Employee versus an independent contractor, exempt versus non-exempt, and then employment at will versus employment contracts. No right or wrong answers here, but which circumstance would you prefer to be in? Sometimes it's helpful to do some self-reflection in this process because you can change where you're applying for, what you're looking for based on what's going to be best for your overall lifestyle. Maybe it's dependent on the industry that you're interested in, but was curious just to have people reflect a little bit based on these definitions. A few more people. And then while
It's really fun to watch the line go back and forth.
While the last couple people are responding, any questions about those definitions? Okay, here I will share the results. So of course there's multiple choices in here, but we have some preferences here for employee versus independent contractor. Again, some of that could be dependent on what your interest areas are. You'll see different industries, different jobs are going to have different distributions of those options. And then employment at will seems to be preferred. Again, this can be personal preference. And so for those who answered with the least less popular responses, it really is dependent on what you're looking for. Interesting. Okay.
And people always think that salary exempt is better, but it's not necessarily, because having a guaranteed number of hours that you work and getting paid overtime for the hours you don't work can lead to you being compensated at an hourly rate that's much better than, say, a super highly paid lawyer who has to work 20 hours a day, right? That hourly rate starts to look like less than minimum wage. Teachers, same idea. Actually, there is no minimum wage applicable to teachers. You can pay them whatever you want, which is why most of them are unionized and have people lobbying for them to get at least minimum wage and cap the number of hours that they're asked to work per day. So it's different in every industry. The other thing you really don't want to be is an independent contractor in a situation where you probably should be an employee, like an Uber driver, right? You are theoretically somebody who's making your own hours and can work as much as you want and make as much money as you want, but there's somebody above your level who is determining market rates and telling you what you can charge and not charge.
Yeah, really good points. So we talked about some of this in terms of other types of contracts that people can enter into. Okay, so let's just, for time purposes, maybe we'll skip over this one real fast. I see a question in the chat, actually. So do you get charged for the hours you work if you bring work home, or is it strictly office-based? Yes, what a relevant question.
Good question. So this has also been a really big deal for employers who have not been used to having people work from home. If you're hourly, right, if you're salaried, it doesn't matter. You can work whenever you want and you don't get paid anymore. But if you're hourly and your employer it's called in New York State, the term is to suffer or permit to work. So if you're allowing your employee to do any work that benefits you as the employer, you have to pay them for it. So for instance, hourly clerical employees, my advice to employers for those individuals in a situation where we can work from work is not to give those people remote access to their email, right? You don't want your clerical employees checking their email off hours because then you have to pay them for it. In a work from home situation, it's really tricky because you have to give remote access. And employers can control that in some ways by having you log in and just making it real clear that, like, look, you don't do work except from this time to this time. And if you are doing work, that was what I said earlier with the discipline. We're going to pay you for that work, but if you keep doing work with us telling you that you're not supposed to work during that time, we're going to start the disciplinary process. Does that make sense? And some people get around that by saying, oh, I'm off the clock and I'm doing work, so it's not an issue. Don't do that. You're creating exposure for your employer, and you're attempting to waive your own rights to compensation and creating the expectation that people are going to work for free, and just don't do that.
It is tempting sometimes. It is a tough one. And habits with work-life balance, right? Even for you personally, that's something that you have to be mindful of. That's a great question. Okay, so we're going to get into some of the pay and negotiation process. So as I was talking about, and again, as this series was named, with knowledge is power, right? I wanted to pull some data specifically from the National Association of Colleges and Employers. This is an organization where Career Services gets a ton of information. They do lots of student surveys, right? Thousands and thousands of people that provide this information. So this organization studies, of course, different trends based on students and whatnot. So in this study that I'm referring to on this slide, what we see here is disparate impact based on race, identity. And so really the goal here in identifying some of these bullets with an example like the fact that white students are more likely to be paid interns than they are to be unpaid or not intern at all. On the flip side, Asian American students are more likely to be paid interns, again, than they are the other options. Whereas we see, for example, Hispanic American students are more likely to have never had an internship than to do a paid or unpaid internship. So this example is specific to internships, right? Using the data from this particular association. Really in identifying some of this data and knowing what's out there, what we can do as far as education and advocating for ourselves is to recognize where some of these trends are going, right? So that we can change the trajectory, bringing them to light so that we can continue to try to make strides, right, for improvement. And so I think, let's see. I think we skipped a slide number here. So in thinking about some of these things, again, in knowing that even for internships, right, we see this problem. Thinking about the protected characteristics again, right? So we know some of this is happening, but the question is, what can we do about
it? And this comes up a lot with internships because interns just don't know whether or not they should be paid, right? The Fair Labor Standards Act governs minimum wage, volunteer services, meals and lodging, tips, overtime, and per diem. It says, you have to be paid if you work. There is a limited exception to allow people to volunteer for nonprofits. You can't volunteer for a for-profit organization, but for a not-for-profit, you can volunteer under a limited circumstance. If you are a paid employee of that not-for-profit, you can't volunteer to do your job for hours that would otherwise constitute overtime or constitute more time for which you need to be paid. I have had a lot of not-for-profit executive directors be shocked at that because they think it's a not-for-profit organization. Of course I can volunteer. I can just decide to not be paid. And the answer is no, you can't. You can certainly volunteer to do something that's different from your job in your spare time. If you are a janitor and you want to volunteer to help with fundraising and I guess table for the organization in your spare time, totally fine, but you cannot volunteer to do your own job. Next slide. Equal pay. So employers are prohibited from paying males and females at different rates for the same work, unless the differential is based on a factor other than sex, such as experience, right? If you've got more years in a profession than somebody else, you can be paid more. But same amount of experience, same job, has to be the same pay. Some local jurisdictions, such as New York City, New York State, have recently, I think New York State's was last year as well, enacted laws prohibiting employers from asking about compensation history. So that's something good to know when you go to apply for jobs in New York State. If they're asking you what your salary history is, don't answer. Next slide. Cheryl found this neat graphic showing the gender pay gap by race relative to white men. And as you can see, there is no situation in which somebody is making the same amount as white men for the same job duties. And if you control for the same job and qualifications, it starts to look a little bit more even. But when you see the uncontrolled data, it starts to show that the gap is even larger, which I would guess is because of the difference in opportunities given to people of different genders and races. 42% of women said they have experienced gender discrimination at work, compared to 20% of men who said they had. One of the most commonly reported forms of discrimination is earning inequality. 25% of women said they have earned less than a man doing the same job, while 5% of men said the same thing. There are endless articles speculating about why this could be, but just something to think about when you go and start to apply for jobs. The other really important thing to know is people culturally, and some employers, but mostly this is a cultural thing, you will hear that it's illegal to talk to other people about your salary. That is not true. You have a right under the National Labor Relations Act to talk to your coworkers about terms and conditions of employment, which can include asking them how much they make. They don't have to tell you, and you don't have to ask, but just know that that is something that you are allowed to do. Next slide. Turn it over to Cheryl.
Yes, and so we've talked a little bit about some of the considerations with salary, specifically with pay. What we wanted to also make sure that we covered, as this is often a gap when I'm talking to students about negotiation in general, thinking about what you might be looking for, what you might accept, are a couple of the other considerations in regards to benefits. So this is definitely simplified on this slide. So I'll say that about health insurance. Some of the things as you're looking at opportunities that may indicate whether an employer is required to offer health insurance are some of the things that are listed. How big the company is does make a difference in their requirements to offer health insurance, as well as your number of hours being considered full-time or not being considered full-time. So those are considerations. Again, it's really going to depend on the exact information about the particular employer. And then in looking at health insurance as well, what are the types of plans they're offering? What are the choices? They're going to differ quite significantly with how much money you are contributing to them, right? So there's a direct relationship between sometimes the money that they're offering you, but then you have to pay a lot for insurance, which is why this is part of the negotiation process. The other thing to consider, which of course is important to people, is time off. So there's some typical structure options, whether it's a one pool of time off that they're offering, and you can kind of use it. Sometimes it's vacation, sometimes it's sick, right? For your purposes. And then there's going to be also employers that divide it into those particular categories. And so some of those considerations, so health insurance, of course, other insurances as well play into it, and then time off tend to be those other two areas that if an employer, for example, is not willing or able to move on what they are offering as far as, just base compensation, these can be areas sometimes that they'll have a little bit of wiggle room in. Okay, and then just really quickly, wanted to also just address this really fast as we're talking about different rights, different processes with job offers. Wanted to talk about U.S. workers just quickly. What we're talking about in terms of federal protections do protect non-U.S. workers as well. With any visa process, the employer is the one responsible for initiating that process. And so that goes administratively, but that also has to do with paying any sponsorship fees, application fees, and whatnot. So I have heard employers who will request reimbursement or try to take it out of a salary amount that they're offering. And that is not something that that really is permissible. It's on the employer to provide you, if they have agreed to, right, on the employer to pay those fees, and they can't ask for reimbursement. Okay, so in knowing that that we've gone over some negotiation kind of techniques, we've breezed over a few things, wanted to also just let you all know that if you're looking for the base level of general negotiation strategy, the steps, the considerations, on the IC Career Services YouTube channel, I've done a full video about just general negotiation. So in viewing this presentation, I think also in viewing that YouTube video, you'll feel like you have a well-rounded kind of knowledge to operate from. And then, of course, I'm always willing to meet with anybody one-on-one about, specific situations with negotiating. I think you're muted, Emily.
Sorry. Now that you know that discriminatory situations can pop up, what do you do if that happens? It's really difficult in practice to prove a discriminatory situation when it comes to salary negotiations and offers, right? Because you have a limited amount of information about what's going on. You only know about your interaction with the person across the table. There are a few things, however, that you can do to advocate for yourself. And one of them is to use data. So find average salaries information based on your location and position title. Look on Glassdoor. Cheryl probably has more good resources for that sort of thing. And showing your value. So documenting in your resume and in your cover letter and in your thank you note, what skills or experiences actually add value to the position and above what is asked for in the job description. So how can you steer the conversation if you're feeling that questions are going to a discriminatory route into what skills and knowledge do I have that will benefit the employer? if they're not interested in your skills and knowledge, it starts to look a little bit more like they're being discriminatory. So no bright line rules here, just some general ideas for how to navigate.
I'll pause to see if there's any questions. Being cognizant of time, we have just a couple more slides, but if there's any questions, then we will stop the slides and answer the questions so that we have enough time. Okay, interrupt me if you come up with one. Otherwise, I'll finish the rest of the slides. We referred really quickly in the beginning to some of the enforcement bodies. If you do experience discrimination, some of the reasons that you would go to one of these places would be to report a claim that you believe it has happened to you, right? Someone to talk to that will investigate charges, potentially recommend remedies, and mediate with where you've experienced it. The EEOC, U.S. Equal Employment Opportunity Commission, is the largest, right, sort of the go-to spot for a lot of the protected characteristics that we're talking about. So I've taken a screenshot of what that main page looks like in terms of filing a charge of discrimination. A couple of others that are a little bit more specific: ada.gov for specific to disability claims, USCIS, Citizen Immigration Services for a discrimination claim, and then a local spot, which can be a good kind of sounding board if you've experienced something. The Tompkins County Workers Center is an accessible place that has a hotline to say, like, hey, this happened, you know, I'd like to just talk about it with someone first. And so this can be a really good spot right in Ithaca. And again, there's the phone number and the email address also. Okay, so I will pause again for questions. Otherwise, if you're interested in similar content as far as knowing about how to advocate for yourself based on the protected characteristics and whatnot that we've talked about, we've done the first portion of this series with job applications and interviews that you can see on the IC Career Services YouTube page already. And then the next one coming up is rights while working. So that's going to have a ton of content right in that hour, but we will fit in everything that we possibly can. So I would encourage you to, you know, view the one that we did before, and then also think about attending the next one. Some similar themes between them all, but when we really are able to focus in, you can feel prepared for what that step is. All right. Any questions? Happy to stay a little bit after. Emily, if you need to go, that's also totally fine. And then if anybody has, you know, questions that they feel more comfortable sending privately, I'll stay on also in the chat. You can send me a private chat message and we can go back and forth. Otherwise, you know, of course, I'm available for appointments and happy to interact that way too.
I do have